lawyers who are doing that. They email me once, they say, oh, okay, motion to compel. I'm like, really? You're going to do that? And then they try it, and then this rule gets thrown back in their face. So you still got to jump through the hoops, Don. It's just that if it's a disclosure concern, in the past, the solution might have been to go ahead and just stuff it into formal discovery. The solution here appears to be that if they're not following their Rule 49 disclosure obligations, there is a provision in Family Rule 65 which talks about the consequences of disobeying disclosure, never mind formal discovery. And then bear in mind also, and this answers the rest of your question, I've noticed, at least in Maricopa County, more and more family court judges are scripting right into their orders a requirement that before you are permitted to file a motion to compel, you must contact Chambers and request a discovery telephone conference first. Now, I don't see that authority in Supreme Court of the Rule 65 for family law practice. The Rule 65 says you can file a motion, but I kind of I'm worried about the extra delay that comes with getting a conference, but if I can tip off the judge that we got a problem here, I almost like the idea of getting on the phone with the courts and the opposing side. And let's talk about what's going on. Why aren't you answering my emails? There's a certain amount of psychological processing that in a good way, they're like, hey, this is wrong. Judge, look what they're doing, man. They haven't answered my emails in 3 weeks. So, and you get to have a conversation about it. So, not that they want to hear you ranting and raving on the phone, but it actually, I think, unless they drag out the rest of the process so long that you lose valuable time, I kind of don't mind this, but you want to be careful because not every judge wants that. I've started compiling a spreadsheet. I've got my staff calling every single division in family court asking, okay, a couple questions. First of all, do you want advanced emailings of all things that we file because you like having advanced copies? Number two, do you like having bench books or do you hate them? And number three, if we have a discovery dispute, do you want the old-fashioned by the book Rule 65 motion, or you want one of these newfangled phone conferences? And I find that they really appreciate the effort to call them. And I'm finding that a lot more judges than I realized would rather have the discovery conference over the phone than read one of my stupid motions. So I hope that answered your question, Don.
Yeah, the only other issue I have is that this is all, I think, very tough for self-represented litigants.
Yeah. Yeah. And that's where I think it's really, well, this gets into a whole discussion about access to justice and how the state bar in general can do a better job of making services available to pro pers. You know, the truth is, and I suspect you agree, that there are going to be certain things that the legal system is going to have to change on a fundamental level if we're really going to level the playing field. I mean, these rules are so intricate. I mean, they spend whole semesters, you know, whether it's a paralegal program, certification for paralegal, whether it's a law school program. I mean, they spend a whole semester just teaching evidence, for crying out loud. And I'm sure paralegals who've gotten their degree know exactly what I'm talking about. It's the same sort of thing. I don't know how you convey all these little twists and turns to a pro per. I suspect you can't. And that's something that's going to have to be, I think, before this is all over, and then this gets into a broader discussion about just how our society handles its own laws and access to the courts and all that. I think we're going to see a lot more changes that are going to make lawyers a lot more uncomfortable than even we're seeing right now, unless we proactively look for ways to help broaden people's understanding. That's kind of my fancy way of saying I have no idea how you teach all this to an unrepresented person, or even how you litigate against an unrepresented person, except to just be the best good faith attorney you can. You know, those of you who know me know that I do a lot of litigation against domestic violence offenders. I hate what they do. I think they give my gender a bad name, but I also feel very strongly about treating them fairly in court. It says a lot about, you know, my practice if I'm going to railroad them or screw with them, and the judges watch for that sort of thing. So if I'm dealing with a pro per who's also a bit of a violent control freak, then I just try to politely say, hey, look, I know you don't want to get involved in this. I know you probably don't want to talk to me, but here are the rules. Here are the things we've got to do. If you don't believe me, here's a copy of the rule. If you don't want to take my copy of the rule, please at least consult with an attorney so that you know I'm not just messing with you. But we've got to have this conversation, or this is going to have to go back to court. And I know the judge would love to see us work this out. And that's kind of a cool email to be able to show as an exhibit later on when the judge is evaluating who the reasonable people were in the case. So if you're worried about these extra things that we have to do and how it will affect representation against pro pers, I look at this as an opportunity for those of us who really enjoy doing best practices and want a good reputation. It's a great chance to kind of say, hey, this is how we do business. Look how well we treated this person, even if they didn't deserve it. So, okay, well, I got about 10 minutes for cool stuff. So I'll try to go fast. We're doing this conference today with Microsoft Teams. And so those of you in Maricopa County also know that Teams has also become the official product of all our court hearings now. They have this Court Connect program through Teams. But I have heard that not everyone is necessarily using the full program for other purposes. So I really want to spend about a half an hour on this, and I'm not going to get that today. Maybe Dawn, if you want me to come back for another component just on office practices, I would love to talk about this, and the answer is yeah. But Teams itself, my office kind of uses a triad between Microsoft OneDrive, Microsoft OneNote, and Microsoft Teams. And I created a whole separate team here to protect client confidentiality. But
Tom,
if you're using the full version,
I'm sorry to interrupt, but I want to tell you, because I can tell already that you are much more well versed in this than I am. The at least part of the topic of our ethics part of the webinar today is over just this topic. So if you want to take as much time as you want, I'll amend my presentation when you're done, because it fits right in with what I was going to go over in part with today's ethics part. So take your time.
Famous last words, Don. Right.
No, it's fine.
Well, I actually have to go at about 12:15 for other reasons, but I'd love to have that extra 15 minutes, and I will gladly come back later if you need more.
Okay.
Because this deserves a good hour. There'll be things I won't be able to get to today. But anyway, if you're using Teams, I'll give you just a brief snapshot so you can see what it looks like. If you get the full license, we have Office 365 for business, and it comes with all the usual applications, Word, PowerPoint, Outlook, all the things you'd expect. But you can also get Microsoft Teams, Microsoft Planner, Microsoft Planner for Tasks, and Task for Planner. And there's all these other applications that Microsoft is constantly adding, and it's been spurred by the pandemic. I think everyone was kind of caught unawares. But if you look here just real quick, I have here in the upper left-hand corner, I don't know if you can see it. There's a blue A that says ALF, that's my law firm, Alonji Law Firm. And I'll just look real quick. Okay, there are all the channels. There are all my clients. Okay, you create channels. You create a team, which in this case would be my law firm, because there's only like 4 of us. And then you can create channels that are either client specific, or I have like different ones dedicated to the law firm for training, for presentations, for interesting literature to read, to improve our practice. And I can create private channels between me and each member of my law firm. So if they want to talk about stuff with me in confidence, they can do that without the rest of the firm looking in. It's incredibly versatile. And then within this, you can see down here, there's a purple button that says New Conversation. I'm just in the General tab. I created this today for presentations and training. And you go here and you can create a conversation. And if you hit this little button right here, the A with the pencil, and I always do this, it blows up into this beautiful, almost like a word processing thing where you can add a subject. And so here, subject says, Tom says hi to the AAIP. Okay, you can mark it as urgent if you want or not. You can also, if you want to, if you've invited other members of your staff onto this channel, you can type in the names, and these are my people. Tasha's my lead paralegal office manager. If you do that, it will flag to her team's app that, hey, something just got posted. I don't have to do that. I can just leave it in here as just simple text, and it will go to this channel. Anyone who has this channel on their team's program will see that it's been bold typeface, but it won't flag as something on their phone. You can add documents. I actually use this a lot, and I bet a lot of you understand and appreciate this. Family law is really draining, as far as self-care, vicarious trauma. And these Teams posts are a great way just to put in fun stuff, between, internal messages, just to offer emotional support, things that don't clutter up your email inbox. I have moved all of my intra-office communications, whether it's just, expressing frustration, amusement, how can we do things better? That is all now completely removed from email. And I think this is a best practices issue, and probably does touch on ethics in terms of competency and office management. But this way, all the email in Outlook is either going to be email from a client to a client, or from a third-party vendor, or from a judge. So it helps clean up the inbox. It moves our private stuff into here. And you can put GIFs in here, hope. Okay, there it is. We all have hope, right? So you can do that. And then even something as simple, if I say, hey, Tasha, you get my memo. If it's an email, you got to answer it. Yeah, Tom, I got the memo. Here, though, I can send it. It stays in the thread, and all she has to do is drag this over and just hit a thumbs up. Now I know she got the message. If I asked her, hey, can you do this? She just says thumbs up. It's done. One less email sitting in my inbox. You can add any kind of a file, and this is where it gets really strong, is I can go here, upload from my computer. I can attach today's presentation. Here it is. And there it is loading. And I hit send. And now anyone who's on this thread can just click on that and see my handouts. Now, this takes me to the next part of the triad, which is OneDrive. I used to keep and a lot of people get nervous about this because they're worried about security. I have found that the security features of the business subscription for OneDrive are every bit as good as the security that I have either on site if I'm doing paper, or that I have just in using other regular electronic storage. Some people might disagree with me. I think it's true, and I've not had a security breach on this in over a year. But I keep a vault. And, it's easier to do it this way here. I'll tell you what. So there's Teams. You may have seen me earlier going to these different statutes when I was talking about disclosure and community property and DV and relocation. Well, here is, I don't want to show clients. So I created these folders here on the left, and I don't know if you can see this, but this is the offline version. The folders are created online. You can create them here if you sync it to your computer, synchronize it. But I have a folder for clients. I have a folder for consultations, people haven't hired me. I got a folder for closed. All the forms that I use in my firm. Legal databases, that's what I was pulling from when I was talking with you guys. Family law. Here's all the case law, the different topics in family law, articles that I find online. I can sometimes put there. I have a section that's called Archive of Wisdom, which is basically things that my paralegals find. If I have them watch a CLE or a program and I want notes about it, they put their notes in a PDF and they upload it here. So we all have the benefit of that information. Interesting publications. I also use newsletters with my clients. We have a cutting room floor. I serve as a judge pro tem, so I keep that there. This folder 98 drafts for Tom. When I have my staff do drafts, I want to have a safe place where they can put confidential stuff, draft stuff, whatever, into their own folders. They get to run it any way they want without my interference. And then when they're ready, so here are their folders down here. When they're ready for a draft, they upload it here, and they just let me know through Teams. They post me a message saying, hey, Tom, check out folder 98 over here on the right on Teams. And so I go to, either Betsy or Noah or Tasha or Tony. I look at the draft. When I'm done with it, I move it into a folder called Reviewed, so they know it's done. And then I personally then upload it into the client's formal OneDrive vault. And its presence in the vault, is what we call it, is our way of all telling each other, hey, it's all good. It's been approved. It's gone out to the other side, or it's about to, and we can safely use that material without worrying about giving up confidential information that's just a private. We can also avoid letting out earlier drafts of something that never should have seen the light of day outside our law firm. And if you want to see the web version of what this looks like, it's right here. There's Microsoft OneDrive. There's our library. There are our documents. Everything I just showed you in Windows Explorer on my downloaded computer is right here. So here's the ALF team. And you can change the icons, look at anything you want. You can make a compact list. You can make a regular list. I like the tiles because they look kind of cool. But those are all the same folders. And the beauty of the synchronization is once you have it synced to your computer, with OneDrive, you can decide how much of it stays available offline, saved on your computer, which takes up hard drive space, but it also makes it available if you ever lose your internet connection. So usually with my client file right here, with my active clients, I'll usually keep those available both on the web and on my computer, but you don't have to. You can make it, hey, just in case, just for logging on, and so you save a ton of computer space on your computer. Most of these folders here I do not have saved on my desktop or my laptop. They're available on the web. So as long as you've got a really good web connection that you trust, and most law firms do, and as long as you're comfortable with the idea of downloading this stuff, it does it just like that. It's super fast. And the beauty of this is my team, they all have access to these folders. And this is something that Microsoft is improving all the time. They have this thing now where I would proceed with caution because we've had, I wouldn't say 50-50 luck, but we've had, in a good way, 70-30, 80-20 luck with this whole co-team authoring where you all open the same document within this OneDrive and you can all make contemporaneous changes to the document while you're all there on the same screen in Microsoft Word. It actually shows you logged in the upper right-hand corner. Every time someone logged in, you can see the changes as they do it. It's really kind of cool and kind of creepy, but it's great for these collaborations. And speaking of trends and waves of the future, even without the pandemic, we were headed this way. And I have found that whenever I get on a Teams conference with my staff and we start doing this thing with screen sharing and co-authoring collaboration, we move way faster. We ask questions back and forth, things get answered. People aren't waiting for a reply email. And, with Microsoft Teams over here on the upper right-hand corner, there's this meet button. This is what Don used to persecute you guys today. Okay. And then, you can meet now. I can schedule a meeting and it will go to my staff. If you use Outlook, and I do, you can also do it through the calendar. So here's the calendar, and I'm going to go to a different week so it doesn't show. I'm going to go to a way different month, so hopefully I'm not showing client stuff. So you see up here in the upper left-hand corner, I'm wiggling the mouse, you can actually schedule a new Teams meeting. You click on the time that you're going to go with, you hit New Teams Meeting, and it opens up right here, and it creates the link for you right there. It's beautiful. You type, it can be people outside your organization. And it says right here, Tom says, hi, I'm going to send this to Don because I can. And I don't know what he's doing on Monday, August 2 at 10 o'clock. It probably won't be talking to me because I'm going to cancel this meeting in a second. But I can set the reminders. I can color code it, which I do. It's office related. And I send it to Don. And then he gets to decide. There it is on my calendar now. And if he wants to, he can accept. He can say get lost, and he can delete it. He can do whatever he wants to it. And in fact, I am going to cancel it right now. Don't take it personally, Don. There you go.
It's fine.
All right. So that's 2/3 of the triad. And that takes me to Microsoft OneNote, which I think is a beautiful, underrated program. It's kind of the ugly stepchild. I found that people either love it or hate it. I like it. And I'll pull it up here. And again, I created a special notebook. If I went into my left menu over here, you would see all my client names. But here's what I do. When I create a section, this is kind of my, well, it's my notes. That's why they call it OneNote. My strategizing. When a client writes and says, man, you wouldn't believe what she did. She just drove her car through a playground at recess at 90 miles an hour. Tom, can you do something about it? So I'll go ahead and do something about it. I'll make a note of it so I don't lose track of issues from the client. So what I'll usually do is if the client sends me an email about a certain substantive issue, I will save it as a PDF and I will put it over here in the OneDrive, in the vault. I have a folder for ER 1.6, Ethical Rule 1.6, dealing with confidentiality. I keep all the information from my client in that folder so it doesn't ever get mixed in with stuff that does go out the door. And then when it comes close to trial, I go in there and I can see all these PDFs where I just say client regarding school enrollment, client regarding violation of child exchange, client regarding illegal relocation. They're all there, so just by looking at the name of the PDF, I know the issues that they're going to talk about. And if I want to, over here, I call this the lab, okay? And then the lab can just be litigation ideas. It can be notes from a phone conference with a client or an expert, or even the opposing side. It can be notes from a phone conference with a judge. And then here, I actually have a page that's called Litany of Weirdness and Bad Behavior. And this is where I put, so for example, cross-examination of opposing party. And then I will start, as information comes to my attention, either I will just type it in, typing in, just points so I don't forget them. Sometimes I'll mention dates and places, but you can also link. If you go here, insert, you can insert a file. I'll go right back to my presentation for today because it's easy. So I go to, this is my OneDrive. And so you know, if you're worried, the creator of the vault can decide who has access and what level of access. Some of these folders, like my personal one down here, my staff can't access. Other ones I make available to everyone. So you actually do have control over that too. But if I go here to Tom, Community Outreach, AAIP, here's today's handouts that I just gave to you guys. And I click on that, and then I get a choice. I can keep it offline on the OneDrive and just insert a link. So if I click on it later, I can open it as long as I have a connection. You can insert the whole darn thing as a printout. It'll show the whole thing on your OneNote, which I don't ever use because it looks ridiculous. But if I wanted to make a point to someone to see a certain page, it's a nice way of just showing their page. Or you can insert it as an attachment. And that's usually what I do. And there it is. So going back to my example, if I've been saving all these client emails about different things that the other side is doing wrong, and if I've been diligent about keeping them as PDFs and marks, I can either take notes or I can just link. And then if I double click it, it opens up and there it is. So when I'm doing my pretrial statement, ideally, all I have to do, if I've been diligent about keeping track of this stuff, all I have to do is go to OneNote and construct all that stuff. If my staff does an interview with a client to put together a parenting plan under section 403.02, all the things that have to go into a parenting plan, Tony puts it in here. So I can see right there, okay, this is what the client wants for the parenting plan. And then I'll put this on my right-hand screen. My left-hand screen will be the pretrial statement, and I just start typing. So it can be a lab. I also will often add a tab for ADR if I want to do notes for a settlement conference memo. If I want to keep track of the client's disclosure cooperation, I also do a tab. I keep a running list of my witnesses and my exhibits. But you can tailor this over here on the left any way you want. You don't have to do it Lawyer Tom's way. That's the beauty of this OneNote program. So those three programs, and then I'll stop because it's 12:10. Those three programs, OneNote, OneDrive, and Teams, I have those apps on my Android. I love Android. I am not an iSheet. I just had to say that. But it works on iPad. I have an iPad. Who am I kidding? It works on iPad. It works on an Android, and it will sync across your devices. So I can pick up my phone right now, and it syncs really fast. I can pick up my phone right now and go to my phone, and I can go to OneDrive. I can go to my Vault. I can go to Community Outreach under my folder. I can go to AAIP. And my presentation will be sitting right here on this phone. So if anything's gone wrong with my laptop, computer, I'm out on the road, I can actually pull everything in my office. That includes OneNote, it includes Teams, and it includes OneDrive. Never mind my email and other stuff. I can pull right off my phone, and it's right there. So I realize that a lot of you may have other software that does the same sort of thing. Great. But the point of this, speaking ethically, is we have a duty of competency that we owe to our clients and the public. We have a duty to safeguard client information to make sure it doesn't get blended or mixed with other material that does not belong there. We also have a duty to make sure that we are responsive and can handle client inquiries on a timely basis. One of the biggest sources of bar complaints from clients is lack of responsiveness, complaints that come from our own clients. And the more you start automating this stuff and making it available, I'm not saying you have to eat into your evening hours or at night. We have a right to personal lives, but just when we're out and about during the business day, to be able to provide a full range of services to a client because you've gotten comfortable with these programs, I can't even describe to you what a difference it's made. We shipped, I actually ordered my staff to shift over to Microsoft Teams last spring when I got the word that eventually the courts would be going with Teams, and I kind of wanted to stay ahead of the curve. I can't even describe just how many different ways it's made our lives better. To the reduced email, to have a place to discuss and post things and talk, to have a vault where everyone can access litigation materials all at once. I know that there are network programs like, I think it's ProLaw or something like that, or WorldDocs, but people are moving more and more away from these network systems that depend on a server at an office. These are all going to cloud-based things now. So as long as your security is good, that's an ethical concern too. You want to make sure that whatever program you're using have the appropriate security. Make sure I would use, as far as just your browser, your computer, I would try to, I've heard that the standard Windows 10 Defender program and Malwarebytes, they're good, they're basic. I went ahead and purchased Kaspersky. Norton has a good program, but if you've got good security on your computer itself and you're using, I would recommend paid licenses. I know it's a drag to pay for them, but I think you also gain some security with a paid business license versus the free versions. And let's face it, I mean, we're all law firms, so we should be able to do that sort of thing. You will find this making your lives so much better in ways that I could spend an hour describing. So it's 12:13. I'm actually going to finish 2 minutes earlier than I predicted, which never happens. But if you want to know more about this, you are always welcome to contact me. Don, the answer is yeah. If you want me to come in and just talk, dedicate, half hour just about cool office management tools and ideas and client communication stuff. This is this is why we do this stuff. This is why we get involved. It's not just drafting documents and arguing in court. It's about getting ourselves out there and trying to make people's lives better. So.
Right. Well, I will follow up with you on that. I absolutely would love to have you back to expand upon, that issue or those topics. But Tom, I can't thank you enough for always coming back and speaking to us. Tremendous value to the materials that you presented today. I wish I could get you into, we're going to have to see if I can get you in to talk to court staff over at Conciliation Services, where I do some work, and because it's a lot of valuable information we don't always get from other sources. Anyways, thank you so much. And if nobody else has any other questions, we'll let Tom go for the day. We appreciate the extra time. And again, I have, Tom, I will distribute the handouts that you have. Did you ever, or do you have, what's a good client referral for you? I always like to ask that question. So, our members can maybe think of you if certain situations come up.
Oh, as far as who to contact in my office?
No, I mean, if we have clients that we can't help, what's a good client referral to you? Just basically anybody that's in family law, has a family law related situation?
Actually, it's ironic because most of my career for over a decade at the beginning was criminal law. I was a prosecutor. But I found myself stuck in family law by default because a lot of my friends, when they found out I was in private practice, I was supposed to do criminal defense for the law firm that hired me, but I had all these friends in the local shelters and stuff. And once they heard I was in private practice, they started sending me family court cases because they had all these victims who were litigating for custody. And from there, I expanded my practice to other family law stuff. So it's mostly family law now, but I do a lot of appeals. I love doing appellate work. So if you especially if a law firm's done a trial but they don't do appellate work and they're looking for collaboration, love to do that. I also do some juvenile court, but it's mostly family law, orders of protection,
all right,
things like
terrific. That. And the materials that I distribute to everybody will have Tom's name and phone number or other contact information as well. So thank you very much, Tom. And I'm going to take back the reins here and we'll move on from there. Thank you.
Power and control. It's yours now. Have a good day, everyone.
You too. All right, everybody. We are going to take just a very brief break, like 3 to 5 minutes, and then we will move on. Tom has covered some of the information that I wanted to cover during my presentation, which I had scheduled for the kind of tail end. So I'm going to kind of pick up from where he left off on some issues, and then we're going to jump to a completely different topic, but some other non-technical related issues as it relates to ethics. So take a break, 3 to 5 minutes, and I'll be right back with you. Okay, I'm just about ready to get started again, or I am ready to get started again. And I guess some of you are already seeing the question that I have on the slide about remote LDP services. And so, the question, I'd like to get an idea about how many of you are currently using some type of remote services like teleconferencing, video conferencing, GoToMeeting, Workplace from Facebook, all those different things. Not sure about how widespread the use is in our little community of certified legal document preparers. So I'll give you guys a minute to put up your hands if that's something that you're doing, and I'll see the numbers rise. They're rising. So I think we have 50 right now. We have 58 people or 56 people in the conference. And so far, 14 of them have raised their hands. And it's rising. So obviously, this is becoming more of a big deal, more prevalent in our community for people to use remote services, teleconferencing, different things like that. And so I wanted to continue to talk about what Tom has brought up in his practice. I wish I had he had the time to maybe discuss more about what he does with meeting with clients. But I did some research on just how much this industry has grown. And I guess the stats that I found were not surprising, but just some examples would be, I think from 10 million in December of 2019, Zoom daily meetings participants increased to 200 million in March of last year, 300 million in April of last year. That's tremendous. Let's see, due to its massive use, Zoom currently consumes approximately 7 million bytes of data per day, or 210,000 terabytes per month. Incredible. Pandemic also boosted the number of active Microsoft Teams users, reaching 17 million worldwide in 2020. So I'm sure I didn't need to tell any of you that this is something that's on the rise. So what are some practical benefits to document preparers, or really anybody in any profession that wants to start using tools like video conferences? Well, one would be reduce travel on both parts, the part of the professional and the part of the customer. You're likely to save a lot of time, likely to have improved collaboration, and the benefits that you can get from recording and archiving. So another question, I'm going to clear everybody's hand raising. At least I think I can do that. Well, everybody lower their hands if they would, because I want to ask you another related question. I'm sure there's a way to do this and I'm just not seeing it. But the next question I have, what are when you're thinking about using remote services like video conferencing, and actually, if you would, use the chat feature to answer this question for whoever wants to. What are the top 2 challenges, or even just the top challenge that you see that you're concerned with in providing remote LDP services in accordance with our code of conduct? Anybody want to share what concerns you might have for the use of remote services or video conference servicing? Oh. Something's going on with the, okay, so I've got a bunch of people offering, let's see. So clients are new to these technologies, certainly that can be a big issue, especially if you're dealing with an older population. Lighting and background is key. Confidentiality, you don't know who's in the room or who's listening. That is probably, that's the big one from my perspective. Now, bear with me a second. Undue influence. Let me get my video conference up again, or my PowerPoint up again. Okay, so certainly, and let's see, we have some other, we start with a phone call prior to starting a Zoom type interaction. Okay, thank you for responding. I believe that one of the big concerns that we should all have is the issue of privacy. So privacy in terms of your privacy, for you and privacy for the client. I use video conferencing in my position at the court occasionally. I never really used it when I was in private practice. But one of the issues that, as far as the privacy for me is that you want to make sure that you're not doing a conference out in the open where other people can see, like if you're at your office, you have coworkers or you have employees or you have other clients maybe walking around or sitting in the waiting room or meeting with other people in your office that can hear or even see, if they pass by your desk, what's going on. So we have an obligation, we have an ethical obligation to keep those communications confidential. And so we want to make sure that when we're engaging in those type of conferences, that we're doing all we can to keep it confidential from our side. And likewise, when we're from the client side, we want to make sure that the client does not have other people, same kind of issues. And I guess from both sides, if someone is on a video conference from home and they might have other family members or friends or roommates that are in earshot or can walk by and see what's going on with the video conference, or people that might be broadcasting from or participating in video conferences from their place of employment, same kind of issues, having just other people, random people walking by. There are issues of confidentiality with those type of conferences. Technical competence, I think Tom covered that pretty thoroughly. Written and verbal disclosures and disclaimers. When we're doing video conferences with people, especially if it's the first meeting, but really any meeting, as everybody's aware, we have an ethical obligation to provide them with the disclosures that we're not attorneys, that we're certified legal document preparers, the disclosure that's set forth in the code of conduct. We want to make sure that we provide that to the client ahead of time or as soon as possible in the conversation. And I'm sure there are various ways that people might do that. I think the most common way would be providing the client with an email ahead of time that includes that disclosure information. But as Tom pointed out, when we're using Teams, it's something that we can provide in, at various times, including as part of a chat, a message through the chat feature. Let's see, another tool that I've seen people use is providing more of a notice of meeting. I guess I referred to this to some extent when I talked about emailing clients ahead of times before video conferences. But I've seen people use a notice of meeting that informs the client or advises the client that what they can do maybe to keep privacy and the importance of privacy during the conference, and also attached to that notice, that email notice, or however it's sent, attached to that, we can include the disclosures that we would normally use if somebody were to come to our office. Somebody just posted, you can sign up for DocuSign. Certainly, DocuSign is a great tool to use. It kind of goes hand in hand with Tom mentioned, or he talked about co-authoring, co-team authoring. I'm curious if anybody wants to post in the chat whether they're doing any of that with clients. But that's certainly something that you can collaborate with your client on work that you're doing with them through Teams by sharing or co-authoring a document while you're video conferencing, and certainly using DocuSign as a way of signing some documents. It doesn't work for everything. Can be a real effective way of getting that done and keeping confidentiality. Anybody? I'm curious if anybody wants to post in the chat whether you've been using, you ever do any co-authoring with clients. Tom mentioned protecting documents. The other issue I wanted to bring up, issue that deals with confidentiality and other related matters, is the issue of recording. And again, another question I wish I could ask Tom before he left, but the issue of recording, whether or not we should record meetings, if we're using Teams or Zoom or some other video conferencing tool, whether or not that's a good idea to record the conversation. Again, I wish if anybody wants to chime in and turn off their mute, I welcome that kind of participation. If they do use recording, if they've made the decision not to record video conferencing with clients, love to hear what your reasoning is. I think certainly it can be a good thing because you can go back and review meetings. You can review recorded meetings for notes and for other purposes. From our position as certified legal document preparers, one concern that I have with recording meetings is the issue of keeping those meetings confidential. As we're aware, while the meeting is confidential, it's not privileged communication. So, the issue can come up is that something that the adverse party can subpoena for, just like they might subpoena our notes or questionnaires or other things that we may use when we're meeting with clients. I don't know if any of you had this experience, but I have. I wouldn't say many times, but there have been several times that over the years that I have had attorneys for the adverse party subpoena my notes. And so I would imagine that the video conference might be subject to subpoena as well. But it's an issue that maybe has to be, that people should probably look into and consider, and at least disclose that it might be an issue to the client. So, and as I mentioned, Tom really went through a lot of the technical parts that I was planning on going through about the use of Teams, the benefits of using Teams. And so, anybody have any questions about the use of technology like video conferencing or other comments? Please raise your hand or post something. Otherwise, I'm going to back up a little bit and go through some of the other slides that I was going to go through during my presentation today. So just kind of go back to the beginning. All right, so The rest, or the other part of the presentation today was that I planned was to go over some of the history of the LDP program and an overview of where we stand right now with the court rules that govern our profession, including Rule 31, Rule 32, Rule 33, and rules and 7-208. I enjoy, and I have done this several times over the years, going over some of the history of our program, kind of how we got to where we are right now. And so for those of you that haven't heard that before, you might find this interesting about where we came from, how we came to be a profession in Arizona, which, as many of you know, is somewhat unique to the rest of the United States. Although there are similar type programs that are popping up around the United States. You know, programs in California and Oregon and Florida and Nevada, and I think a few other states that have some type of regulated program for non-attorneys. But many of you are aware that up until 1985. The legal profession in Arizona was really monopolized by lawyers. And you had to be obviously a member of the state bar as a condition of being able to provide any legal services to the public. Non-lawyers were prohibited from engaging in the practice of law by a UPL statute, and that statute imposed criminal penalties for anybody that violated it. You know, during that time, and I think the mentality for, you know, most has changed, although there's still people who disagree with this, but during that time, I think the public was viewed by lawmakers in the judiciary as well as being too ignorant to handle their own legal matters, not able to do so. And it was really unthinkable that somebody without a law degree could figure out how to process things like their own divorce, a bankruptcy, or form a corporation, or draft a will or a trust. A non-lawyer offering legal document preparation services was viewed as a criminal, taking advantage of an unsuspecting public. In the 1970s, that attitude changed quite a bit with the advent of legal self-help kits, books, and seminars put on people that were promoting these self-help kits and books in Arizona and elsewhere around the United States. And, you know, as that self-help movement grew, the general public became more aware that they could handle more legal matters by themselves. In 1985 is really kind of the birth of the independent paralegal movement. Independent paralegals, when I use that phrase, I'm not sure if any of you still call yourselves independent paralegals, but prior to certification, that's what most document preparers called themselves, independent paralegals, meaning that you provide paralegal type services outside the supervision of an attorney. So what happened in 1985 was that the State Bar of Arizona and the Arizona legislature got into a little tiff about the bar not wanting to open up their disciplinary records to the legislature. And as a result, the Arizona State Legislature sunsetted the unauthorized practice of law statute, which basically took away the teeth of enforcement for people that wanted to engage in some form of practicing law, providing document preparation services, for example. From there, the bar attempted several times throughout the 1990s, to get the UPL statute reenacted or to have the legislature pass a new UPL statute. Those of us that were around at that time, and there are many of us still practicing today, we would go to the legislature and talk to whoever was on the Judiciary Committee reviewing such things, and each time we were able to convince them to either table the matter or just vote it down. It wasn't until late, I believe it was 1999, that we caught wind that the bar was going to take another crack at it Except this time using the Supreme Court rules to redefine or more specifically define the practice of law and essentially legislate people that were practicing as independent paralegals out of existence. So, one of the main arguments they had at the time was that the state bar had all these, I think they were roughly, 440 or 450 complaints that they had, supposedly alleged complaints against people that were promoting themselves as document preparers. And so they were using these alleged complaints as a basis and as grounds to go to the Arizona Supreme Court and ask the court to pass some new rules that would legislate us out of existence. Fortunately, we banded together under, and that's really marked the creation of the Arizona Association of Independent Paralegals, and we got some help from some public interest law firms and others, and basically challenged the bar's efforts. And we did things like we picketed the Arizona Supreme Court. We picketed the bar's conference that year in the summer months in Tucson. And we went to the newspapers and got as much attention as we could. As a result, the Chief Justice at the time, Chief Justice Charles Jones, decided to form an ad hoc committee on the unauthorized practice of law. And make a long story short, the result of that was the Certified Legal Document Preparer Program, which went into effect in, I believe it was June of 2003 was when they started to grant licenses or certifications, I should say, to people that qualified. And so that's what started with our program. So from there, the program now, let's see where we stand today. Some of you might not be aware that some of the rules, not with 7-208, but some of the rules, Supreme Court rules that impact our program or impact the practice of law have changed recently. In fact, effective January 1st of this year, the court has put into effect kind of revised definitions, and I wanted to kind of go over that with you. So the definition of the practice of law now means providing legal advice or services to or for another by, and it gives, I think, 5 different categories: preparing or expressing legal opinions to or for another person or entity, representing a person or entity in a judicial, quasi-judicial, or administrative proceeding or other formal disciplinary resolution process such as arbitration or mediation, preparing a document in any medium on behalf of a specific person or entity for filing in any court, administrative agency, or tribunal. The 4th one is negotiating legal rights or responsibilities on behalf of a specific person or entity. And the 5th one is preparing a document in any medium intended to affect or secure a specific person's or entity's legal rights. So that's pretty general. That pretty much, I think that covers anything you could possibly do that impacts legal rights, would be interpreted as the practice of law. So now the rule goes on to define the unauthorized practice of law or I should say, the authorized practice of law is someone that engages in the practice of law in Arizona or represents that they're authorized to, only if the person is an active member in good standing with the state bar or someone specifically authorized to do so under rules 31.3, 38, or 39. And so basically that impacts us. 31.2 has an exception or exemption, I should say exception, for legal document preparers and now legal paraprofessionals stating that either professional may perform services in compliance with the Arizona Code of Judicial Administration. However, disbarred or suspended attorneys may only be certified as legal document preparers or legal paraprofessionals if approved by the Supreme Court. So, but basically, Rule 31.3 carves out several exceptions to the unauthorized practice of law, and our program is one of them. And under the Code of Judicial Conduct or Judicial Administration, I mean, that defines what our profession does, and how you're certified and how we're disciplined, and what our code of conduct should be. And so I'm going to skip over some of that because we've got such limited time. But the bottom line is, well, I'm going to go over the roles and responsibilities, but not so many of the code of the detail in the code of conduct. So, as all of you are probably aware, we're authorized to prepare or provide legal documents without the supervision of an attorney for an entity or a member of the public in any legal matter when that entity or person is not represented by an attorney. So, basically, as an LDP, you can potentially prepare any legal document subject to the other court rules in the code of conduct. Let's see. Catch up with myself here. So with the time we have left, I'm going to kind of jump to, the topic of, what's the best way, what's the best way we can conduct ourselves on a regular basis to make sure that we're complying with the code of conduct and all other rules that impact us. I'm skipping around because I've carved out what Tom went through earlier. Here we go. Okay. So, again, how do we apply the rules that are set forth in 7-208 in our daily practice? What's the best way to do that? And I would submit to you that the way that you communicate with clients, how you gather documentation and information from the clients is what's key to ethical practice. It promotes ethical practice by setting boundaries and clarifying roles and responsibilities. And it also protects and defends you against possible complaints. So I would say it starts with your attitude and your approach, knowing what you do and what you don't do. So what do I mean by that? I think the biggest issue that I've seen, one of the biggest issues I've seen with people that have problems with the Board of Legal Document Preparers, maybe have complaints that are eventually filed against them. The biggest issue that I see is really wanting to do too much. I understand the idea of wanting to serve your client the best you can, wanting to apply your knowledge, your skills the best you can, but too many people go beyond the scope of the authority of 7-208. Again, I would just to submit to you that you're a professional document preparer, not a lawyer, and we should be proud of that and own it. What's also important there is that I think a lot of times we lose sight of is that clients respect the limitations that we have as document preparers, and they understand if we set those boundaries, we tell them what those limits are, that we're not going to lose clients. We're more likely to gain their respect and understanding about what we can and can't do for them. So, when in my practice, I would always tell other people in the office, other document preparers that I train, to train your customers. Train your customer by developing a presentation, conversational habits that incorporate the disclaimers or the description of our and limitations of our practice into what you say to them. So always be setting boundaries and enforcing them. So, for example, one of the biggest things clients will, especially clients that may be, emotional, desperate in what's going on in their lives, family law cases, civil cases, probate cases, people want you to tell them what to do. And sometimes it's hard to reject the urge to not tell them what we think they should do. And so, being able to tell clients that I can't tell you what to do, I can't tell you what's going to happen when you go to trial, I can't tell you what the judge is likely to order, is a tough thing to do. But when we set those boundaries, we're not going to lose clients. The client just knows that it's not advice that we can provide them. What do we do when clients ask us what to do? Well, we can certainly give general factual legal information and talk about options, general options. So when, just by way of example, if you have somebody that comes to you that is an estate planning client, and they're coming to you for you to potentially prepare a will or a trust or something else, but the client has no idea what they want, what they should have you prepare for them. Rather than give them specific advice on what you think they should do, starting off by talking about generally, this is what people do, or this is what happens when, what I would do when I was in practice, I would talk about generally, this is what happens with people when people die without a will. Then this is what happens when people have a will. And then add to that from there, direct beneficiary designations. This is why some people do a living trust. And by giving them that factual general information, discussing general strategies, general options, you educate the client and you make it easier for the client to make decisions on what he or she thinks that they should do, and that can be applied to any type of matter, whether it be estate planning or civil or probate or family law. So I would say that those are best practices. I refer to it as constantly incorporating into your communication with clients disclosure and disclaimer communication practices. So disclosure and disclaimer communication practices. And when do we practice those? We say that all the time in our face-to-face meetings, in our telephonic meetings, in our electronic communications, our emails. Anytime we have an opportunity, we should be reinforcing this with the client what the scope of our authority is to practice law, and we are practicing law to some extent. Okay. So we've got about 5 minutes left. Some other tools that I recommend document preparers use that I don't see people use all the time. And again, I feel like the reason for document preparers not using certain tools that promote best practices, that promote confidentiality, that promote the idea of giving clients the information that they need so they understand the scope of our services, what we can and we cannot do. One is to provide clients with that initial disclosure in writing when they come in the door, and I recommend you have people sign it. So typical disclosure, the minimum is what you see on the screen right now. So a legal document preparer shall inform the consumer in writing that a legal document preparer is not a lawyer, is not employed by a lawyer, and cannot give legal advice, and that communications with legal document preparers are not privileged. That's the minimum we have to give in writing. I usually go beyond that in either an engagement letter, or just in the initial contract for services that I used to have clients sign, and that way, again, you've set the tone. You have it in writing that they understand what the scope of your services can be, and there's no misunderstandings, and that can serve to protect you if you ever have an issue with the Board of Legal Document Preparers. If there's ever a question whether or not you gave that disclosure, or if you've been acting beyond the scope of your authority. Another tool that is that's beneficial that I think most people use are questionnaires. Questionnaires advantages are that advantages in accuracy and clarity for the client. It's also proof that the client gave you particular instructions with what the client wants and doesn't want. So, in my practice, I used questionnaires for everything, for whether it be a divorce or estate planning. Just by way of example, in a divorce, I know all the information I'm going to need so I can prepare a divorce petition. So I get that information through the questionnaire: the names, address, dates of birth, social security numbers if applicable, a statement about how they want to divide different assets and liabilities. If there are children involved, the information about the children, what they want for legal decision-making, parenting time, for regular parenting time, during the summer months, during holidays. All that information is gathered through a questionnaire. And if there's, once it's prepared, if there's some issue with the documents that are prepared, well, first of all, the most important thing is accuracy from the beginning. But if there is an issue that turns up later that either the client left something out, or the client claims that they didn't give you certain information to put into the documents, you have proof about what the client gave you. Now, other ways of information gathering, interviews, direct input. Some people will interview their clients, and input the information into documents as they're meeting. There are some advantages to that, especially if you need more comprehensive answers. For example, if you're, let's stick with family law, if you're doing some type of an emergency petition for legal decision-making and parenting time, and you need some kind of narrative information about the basis for that, that might be easier to gather with an interview, although I would still recommend using a questionnaire. Other document issues, good, best practices, retain the correspondence you have with clients, retain, notes about meetings, telephone calls, take notes when you're meeting with clients, especially if you're not using questionnaires, so you have some basis to show where the information came from. Document reviews. When you meet with clients, make sure you give them adequate time to review a document. If there are changes made or corrections, I think maybe not all the time it's not necessary, but I always had a practice of retaining drafts. Sometimes I would retain drafts that had little notes on it, or the sticky notes that the client might put, or handwriting from in the client's handwriting. Lastly, so these are all good business practices to protect the client and to protect you in case something ever goes wrong. And then lastly, I recommend that people use document approvals. Document approval, I have an example of one of the language that might go into something. Basically, it's just a document that you have the client sign after they reviewed the document that indicates that they reviewed it, they accept it the way it is, that they've reviewed it for any errors or typos, and it looks good the way it is. And, again, that way you have proof that the client did in fact read everything and approved everything. So if something goes wrong in the future, you have, you're kind of covered, at least to some extent. So, those are recommendations that I have for people. If anybody has any questions about, and maybe would like to see other samples of like a document approval or an initial disclosure that they might use, I'd be happy to share those. You can email me and I'm happy to provide that. I will be providing a copy of my PowerPoint, the handout portion with your certificate of completion. So are there any questions anybody has? I didn't see any questions come up in the chats, but it is 1 o'clock, and so it's time for me to show you the last word, the verification word. And somebody asked, "Have I heard about education yet?" I'm not sure. Can you be more specific? What are you asking? Oh, for paraprofessional. So I think the question is asking about the new paraprofessional program. Are you asking if, well, I'm still not sure. Do you mind turning off your mic or turning on your mic and asking directly? Susan?
Okay, can you hear me?
I can hear you, yes.
Okay, I was just wondering if you know of any educational opportunities, I guess, is the question I'm asking. For the new paraprofessional, if you've seen anything pop up. I did speak with one of the professors at Yavapai College in Prescott, and they are in the process of putting together a program. I just didn't know if anything else had been
I have not. I've also heard. I have also heard that the U of A might be putting something together, but I will follow up on that for future CLE or continuing education classes. Maybe we have a class at the end of this month again on the last Saturday of the month, and I'll see if I can get some more information by then. It's something that I am constantly looking into, but yeah, you're referring specifically to programs developed specifically for that licensure, for that certification. I mean, you are aware, that obviously you can have. There are other programs that you can use for your education, but yeah, there are a couple. Colleges that I understand are in the process of putting together some kind of special training program, educational training program for so people can become licensed. I also, there are still just some other general questions about qualifying based upon your work history that I'm also looking into, that hopefully will have more clarification in the next 30 to 60 days.
Sweet.
So go ahead.
Yes, you answered my question.
Okay, all right. Anybody else have any other questions? So if that's a last question, I'm going to hold up the last word of the day, which is SOCK, S-O-C-K. So you want to write down this word, and hopefully you got the other two verification words. And if you would, as soon as or anytime, today or over the next few days, send me an email with the 3 words, and I will respond with the certificate. Oh, somebody wants to. Okay.
Can you show the word, please?
Yes. Can you see it?
No. I see your slide.
Here, well, let me turn off my presentation. That would be better.
There it is.
There it is. Okay, sorry about that. So the final word is SOCK, S-O-C-K. And okay. And then again, you want to send me those 3 words by email, and I'll respond with your certificate of completion as well as the handouts. But that would pretty much conclude our presentation today. And I'd love to hear if any of you have comments about the presenters. I think our 2 presenters did fantastic today. We're really fortunate to have them. And I encourage you to, if you have any questions about their particular specialties, by all means, give them a call. They're great people, great resources, and they've always been supportive of AAIP. So if there's no other questions, then I think we are done for the day. And I thank you all for participating.
Hello? How are you doing?
I'm trying to type.
Oh, can I help you?
Well, you could if you want.
Where are you?
Right here.
Words are a bag.
Tire bag is hot. I just need to sign. Thanks, Carl. But I don't know what to do.
Get your hand up for that for one thing. Get down there and type thanks, Carl. Wait a minute. Okay, now it should work.
Mhm.
It says Carl and Katie Cunningham.
I know it is. It's just.
Wait, it looks like you've already sent it.
No, I haven't.
Sent. Let me see. Yeah, you.
Where?
Oh no, you didn't.
I'll just go ahead and send
Okay,
it.
go into draft. Draft.
Where's draft at?
There you go. Click on it. Okay, we need to get rid of MK.
I don't think it's like this.
Give me this. Of course you do. You want the certificate to say Carl and Katie?
No.
No. Can you get out of the way? Let me get in here.
Sure.
Well, I need to try and get in there and figure out what's wrong. If you're sitting there, I can't. Okay. I know what's wrong. Okay, now type your message and then just hit send. Firebag sock.
Yep.
Good job, Rick. Let me see it before you send it.
I don't know. That's fucked up.
Type your name. Type your name.
There you go. There it is.
Cunningham.
There it is with the line through
Carl.
it.
Type Cunningham.
I don't know,
Because you touched
because
something.
I did something, yes.
Okay, move. That line on. I don't even know how you do the thing. Okay, so something up here you clicked. What is shit all over the screen? What the fuck? No, I'm not gonna just forget it. There, now hit send. You hit send.
Oh, please. You hit send. Well, now it shows. Trump enemy confesses to her.
Those are the incoming.
I know, but there's thank Trump for defunding who?
Are you trying to see if it went?
Yeah, I'm trying to see.
Then go to the inbox. Click inbox first. Click draft. This was the one we need to get rid of. Back to Sam. There you go.
Thank Trump for defunding who?
Now, Don Stewart.
Ah,
Click on it and read what you sent.
yep.
Then
No,
click on inbox, so you take it back to the inbox. Click on anything else. The other day you were in the emails and I took you through try and figure out the inbox. Right? The new emails were at the back of the pages. The one I already read.
Katie?
Okay.
I guess other than it goes to the trash folder to show me this thing. I guess maybe that's where we put it.
We deleted Carl in the trash folder. That was the draft. That was the one that.
Okay, would you calm down?
Just go to the inbox.
I'll put it here.
Don't do anything.
Hmm.
You already sent it. If you want to see sent, now you got something in the draft again. Go
Draft.
back to draft. What is in there? First off, we'll verify you sent it. Let's do it. Right there. All done.
Okay.
So now draft. Click delete. Inbox. Don't need this. Don't need